Hello and welcome. Before I share a few of the recent court filings from the Karen Reed case, I wanted to read this to you guys. I did share this through a post on YouTube when it was released on the 31st, but I will read it here in case there's anyone who can't read cursive. So again, it's dated January 31st, 2025, and it reads, after hearing and review of the written submissions, I have determined that I can decide this motion without any further hearing. B. Canoni. And it's in response to the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. I hate that title. Okay. Let's read the other recent court filings. And I believe some people were confused by Judge Beverly Canoni's written response to the Commonwealth's motion to exclude Richard Green. Judge Beverly Canoni did not make her decision yet. As of February 2nd, 2025, Judge Beverly Canoni did not make her decision on the Commonwealth's motion. She merely stated that she will not have another hearing pertaining to the motion to exclude Richard Green. So she will be making her decision on her own without another hearing. So here's hoping that Richard Green gets to stay. And guys, if you have been following me long enough, you know, and I know, that Richard Green's analysis of the cell phone extractions are scientifically based. So to me, the only way Judge Beverly Canoni will deny the Commonwealth's motion to exclude Richard Green is if Judge Beverly Canoni understands the scientific method and if she understands what hash values are. So we'll see. She was willing to keep Dr. Marie Russell. I am hoping she is willing to keep Richard Green. And guys, if she does not allow Richard Green to keep testifying, it will just further prove her corruption in this case. How can you deny something that is scientifically proven, something that can be replicated through 5 different applications? How can you deny it at this point, you know? And to me, the people who are believing Jennifer McCabe, which again are like 10%, if that, of the population, the people who believe Jennifer McCabe did not make that search are the people who do not understand what a hash value is, and they do not understand the scientific method. And they do not understand that using 5 different tools and coming to the same conclusion, despite the 5 different tools, is scientific certainty that Jennifer McCabe made that search. No one can tell me otherwise, okay? I'm a little biased, yeah, but I'm also pro-science here. Just putting that out there. Okay, this document was submitted January 31, 2025. It reads Commonwealth versus Karen Reed. Commonwealth's opposition to defendants Karen Reed's motion to recover expert-related expenses from the Commonwealth. And if you guys don't remember that motion, I will leave the link in the description below to my commentary video about that motion from the defense. The document reads, now comes the Commonwealth in the above captioned matter and opposes the defendant's motion to recover expert expenses from the Commonwealth. The defendant's suggestion that the Commonwealth misled or induced the defendant to incur costs to have an out-of-state expert travel to the Canton Police Department is a distortion of the facts and has no legal merit. I can already tell Hank Brennan wrote this. Gaslighter. Okay, continuing. The Commonwealth requests the court deny this motion without a hearing. You see that, guys? Like the prosecution doesn't even want a hearing for this motion. They want Judge Bev to make her decision without a hearing. Very interesting. I wonder why. Continuing, the Commonwealth has provided the defendant with numerous videos from the Canton Police Department throughout the entirety of this case. At no time has the defense ever made a formal preservation request. In November 2024, the defense made an informal discovery request relative to additional Canton Police Department videos. Special Assistant District Attorney Brennan responded on November 25, 2024, informing the defense that he would inquire of the Canton Police Department and/or keeper of the records to attempt to identify any potential chain of custody of video footage provided and would request any documentation that may exist relative to the chain of custody of surveillance video. During the week of December 1st, 2024, ADA Brennan spoke by phone with Attorney Jackson and his counsel. Attorney Jackson asked if the Commonwealth would consider allowing a defense expert to access the Canton Police Department's camera system, in parentheses NVR. See defendant motion at page 2. No motion or order had been allowed or even filled relative to this request. ADA Brennan agreed to accommodate the defense's informal request. Guys, pulling away from this court document, who cares if there was no court order with this request? As if both sides can't communicate amicably, civilly, in order to achieve favors or in order to accomplish things from either side without Judge Beverly Cannoni's assistance. Like, what is Hank Brennan's point here? Like, of course, a defense team can contact a prosecution team and get things done outside of a court's decision. And this is one of those things. And for Hank Brennan to admit, in the last sentence, ADA Brennan agreed to accommodate the defense's informal request. Guys, like, he's telling on himself. He's telling on himself. Like, in the defense's motion to recover expert expenses, the defense says that Hank Brennan, agreed to accommodate them. Hank Brennan agreed to coordinate with the Canton PD. And here's Hank Brennan agreeing that that's what happened. Okay, I'm just saying, guys, if you're going to agree that if you're going to agree on that detail, the onus is on you to deliver your end of that request. The onus was on Hank Brennan to deliver his end of the defense's request. Continuing, during the phone call, Attorney Jackson expressed concern that the video footage would no longer be stored, and ADA Brennan acknowledged and shared Attorney Jackson's concern given the passage of time. Attorney Jackson requested the Commonwealth refrain from accessing the system prior to the defense expert's examination. ADA Brennan met with Canton Police Chief Rafferty and received permission for the defense to search for video from the Canton Police Department DVR system relative to the storage of the defendant's vehicle. Pursuant to Attorney Jackson's request, ADA Brennan directed Chief Rafferty to advise her staff not to disturb the NVR video system prior to the defendant's expert examination. ADA Brennan also invited the defense to tour the entire Canton Police Station and note all camera locations. Also, Brennan informed the defense that the Commonwealth would have a forensic examiner from the Norfolk County District Attorney's Office and Massachusetts State Police trooper present. The Commonwealth videotaped the procedure to memorialize the event. The defense expert visited the Canton Police Department on December 12, 2024. It was learned at that time, nearly 3 years after the incident, that the footage on the NVR was overwritten and the system no longer maintained the original surveillance footage. Moreover, in efforts to identify video footage and chain of custody, ADA Brennan visited the Canton Police Department, viewed camera locations, and had a discussion with retired Sergeant, oh man, what's that last name? D. Campietro. Oh my gosh. Okay, I'm just gonna call him Sergeant D. Served as the officer who originally obtained and produced video from the Canton Police Department. Sergeant D informed ADA Brennan that he routinely would make a copy of footage obtained from the NVR and preserve footage on the department's work server hard drive, which is separate from the NVR file system. Prior to its motion, quote, for costs, end quote, ADA Brennan informed defense counsel during a conference call that retired Sergeant D would routinely save video copied from the NVR onto the department's hard drive. ADA Brennan offered to produce a copy of the stored footage from the Canton Police Department's hard drive, or alternatively allow the defense direct access to the hard drive. The defense deferred this offer and has requested further information about the hard drive storage that is forthcoming. The Commonwealth never agreed that nearly 3 years later, on December 12, 2024, that video footage from January 29, 2022 would still be stored on the NVR system, nor did the Commonwealth in any way hinder the defense's desire to have a defense expert view the Canton Police Department NVR. The footage simply no longer exists on the NVR because of the time that has elapsed. Therefore, the defendant's motion should be denied without the necessity of a hearing. Respectfully submitted for the Commonwealth, Hank Brennan. I knew this was Hank Brennan. It was dated January 29, 2025. So it's a he said, she said thing, guys. You know, it's a he said, she said thing. And unless Alan Jackson was recording his phone conversation with Hank Brennan, there's no way to know what that conversation was about. And I'm saying it like this because ultimately Judge Bev is going to have to make her decision upon the facts. And if it's he said, she said, and the Commonwealth, the prosecution, Hank Brennan, is saying that he did not agree or suggest that the DVR system would still have video footage, it's like, what is it? Detrimental reliance. That's the civil issue here, that the Karen Reed defense team was relying on Hank Brennan's words, and it cost them $12,000. And because the DVR system, according to Canton PD, no longer has that footage saved, and the Canton PD also doesn't have a backup of the footage, according to the defense's motion, there's no way for the defense to have an expert review the DVR system. There's no point. So I'm believing what the defense said, obviously, because Hank Brennan has already proven himself to be a liar. And guys, at no point during this case did the defense contradict themselves. There was never a point in this entire Karen Reed case in which the defense contradicted themselves. It is Hank Brennan who has continued to contradict himself. It is the prosecution, Lally and McLaughlin. They've all contradicted themselves, and they have all proven themselves to be liars. So I'm saying I would not take Hank Brennan's word at face value. I believe Alan Jackson and the rest of the defense team when they say that the prosecution said this would all be okay, coordinated with Canton PD, and essentially prepared Canton PD to receive the defense's expert so that he could review the DVR system. But, you know, in the second page where Hank Brennan mentions attorney Alan Jackson expressed concern that the video footage would no longer be stored, and ADA Brennan acknowledged and shared attorney Jackson's concerns given the passage of time. This is like Hank Brennan's attempt to be like, yeah, it might not still be there. I agree with you, Alan Jackson. Like, it's been a long time. It's been 3 years. It might not be there anymore, you know? Like, it's like, did that conversation really take place? We can't know unless it was recorded, you know? And I don't know, guys. Like, I don't know why there would be such a phone call anyway. I think at this point, the defense should not be calling the prosecution. Everything between the defense and the prosecution should be via email. It should be written. Like, everything between the defense and the prosecution at this point should be provable. Like, every bit of communication that is going on, every bit of correspondence taking place between the defense and the prosecution should be provable. It should be written. It should be through email so that there's no denying who said what. So I am looking forward to the defense's response to this. You know, and like, if I were the judge, I would call a hearing, because I'm not going to play the he said, she said. I want to hear both sides. So I do hope Judge Bev allows a hearing to take place for this matter. Again, Hank Brennan, zero credibility. Despite how convincing this motion may appear in written form, he comes off as rather reasonable here. And I didn't quite notice any like throwing shade, which Hank Brennan tends to do. Again, the motion to exclude Richard Green, debunked opinions, like, that's throwing shade, guys. It's tainting the picture here. And I didn't quite see that in this motion, but this motion could be made up of lies. And in those lies is more of Hank Brennan playing dirty anyway. So we will see how it turns out, guys. I am praying that Karen Reed is permitted to be recompensed for those expenses. Again, it was over $12,000, guys. And the guy flew from Arizona one day, and the immediate next day he flew back to Arizona. You know, I'm just saying, the defense team is thorough. The defense team is careful. I highly doubt they would have allowed this dude to fly from Arizona to Massachusetts if they didn't have all their ducks in a row. Highly doubtful. My stance here is that Adam Lally and Hank Brennan must be lying. Thank you for watching.